Mr. Byrne.
Thank you. I'm now on to, I think, what was my sixth category, which are the hypotheticals. Hypothetical 1, member of the public arrives and takes over the warning from Mr. Kendall. These are all, as we understand these hypotheticals, these are all, is it an Aunt Sally? Oh, they're arguments that are put up by Mr. Warnock to say there's no liability in these 4 situations, and therefore there can't be any liability in our situation. What we're doing now is we're distinguishing them and saying whether we agree or we don't disagree, or whether we agree or we disagree, rather. Right, so first one, he stops the motorist, takes over from Kendall, let's say because Kendall was sent to hospital. Second limb of it, person then leaves and then the accident follows. Mr. Warnock says that they could not conceivably be liable. Well, we don't agree with that. Or we don't agree, rather, that there is no positive act of making matters worse. I mean, these are our answers. Once the Good Samaritan arrives, they are indeed subject to a duty not to make matters worse. It all depends, obviously, on the facts. The answer to this case is not the absence of a duty. The answer to this case is that there's unlikely to be a breach of that duty not to make matters worse in the case of an ordinary person in an emergency situation, because it's highly unlikely that they would be found negligent. So that's the sort of common sense.
What about the point, though, that if they'd done exactly the same as the police had done, so put a warning sign out?
Well, if they were not negligent, if they had not made matters worse.
But why would it be different from the police? Is what I'm asking.
Well, hang on. Let me just work my way through it,
yes,
then I'll try and answer that. In our case, we're talking about trained police officers subject to the Bolam standard. We know what's happened in the disciplinary processes. They've been found liable for gross negligence.
I'm not
already
sure
made the point about where you
is that
find
something
the
we
duty.
can take account of?
Yeah. Well. I mean, this is just an illustration. But what the point I'm making here.
Mr. Bowen, I don't really see how we could take account of what happened.
I'm sorry?
I don't see how we could take account or give any real weight to what happened in the disciplinary process when we know nothing whatsoever about it, other than some pleaded facts.
Well, I'm dealing here with the fact that the answer to this hypothetical is not that there's no duty, that in reality there is likely to be an argument about breach, about the standard of care. And there's far more likely to be a breach of duty if you are a trained officer and a trained emergency response team than if you are an ordinary person. Query whether causation would be present in Mr. Warnock's scenario. How long did the volunteer rescuer, how long was he there for? Did he or she give up straight away? So we think that the answer is the lack of negligence on the behalf of the replacement rescuer. That's the answer to the conundrum that Mr. Warnock poses. And we can't let his positive act argument cloud the fact that there always needs to be demonstration of breach. And what's controlling liability in that scenario is the standard of care. So that's the difference, we think, between the volunteer and the professional rescuer. They might have the same or similar duties, but what we expect from them in terms of the standard of care is very different. So that's number one. Number two, Mr. Kendall waves down the traffic and stops. Mr. Warnock says, not liable. We agree with that. We agree with that because he has quite simply not made matters worse. If we apply the hypothetical approach in capital and counties, this is the comparing what really happened with what might have happened, 1034C to E, then but for his action, i.e. if he had not intervened at all, then the situation would have been exactly the same, i.e. nobody actually warning. no liability. Hypothetical 3, based on capital and counties, I think. The fire brigade attend, they turn the sprinklers on, and then they turn them off again. Not liable, says Mr. Warnock. Doesn't assist with the conundrum in our case. We agree with him. The reason we agree with him is because it's not a making matters worse case. As before they arrived and after they left, the situation was exactly the same. Namely, the sprinklers were not on. So it's a simple application, we say, of the macro and comparative, real and hypothetical approach that Lord Justice Stuart-Smith was explaining at 1032. That was the scenario, that's why liability was not found in capital and counties. Then we get to hypothetical number 4. Member of the public comes forward and says, I'm a doctor. And that prevents somebody else who might be a better doctor coming forward. I think that was broadly the scenario set up. Again, Mr. Warnock says not liable. Well, our answer to that, I split it up into 8 points. Again, this is not a making matters worse case. The rule is that once the doctor, so number 2, the rule is that once the doctor starts doing something, he's only liable if he acts negligently and made the situation worse than it would have been if either firstly he'd done nothing at all and left the person alone, either, well, to suffer or to die, whatever the facts are, or B, it could be shown that matters were made worse than if the second doctor had come along. There's no negligence under those circumstances. And number 3, it falls more naturally within the territory of the second to farthest exception, i.e. A has done something which prevents another from protecting B from that danger. And we say that surely this scenario is not the case of preventing another from intervening, as the rescuer was initially a doctor. So, one of the main points is that this 4th hypothetical is not an analogy which in any way suggests non-liability in our case. Our case is not about Kendall being a better rescuer or the police being a worse rescuer. Our case is about, had they done nothing at all, he would have remained on scene as a rescuer. So again, apples and pears. It's about the police neutralising what Kendall was doing. So finally, point number 8, the comparator for our case would be a doctor who comes forward and takes over from, let's say, a paramedic who was doing something. And then that doctor who takes over actually does nothing at all. He takes over responsibility or control. The paramedic has left, Kendall, and then the doctor just sits on his hands and then he leaves. That's the analogy that runs.
Could you,
So
I'm sorry, can I just ask, could you articulate very precisely what your case is about how and why Mr. Kendall left? Because I don't understand it.
Sorry, how and why?
Mr. Kendall left. He left in an ambulance.
Yeah.
I don't understand it to be pleaded or asserted that he was told to go. I don't understand it to be pleaded or asserted that anything was said to him about the role of the police at all. So I think we do need...
Well, I think we've dealt with that at paragraph 22 of the pleading, haven't we?
Okay, so your case at its highest is paragraphs 22 and 23.
Can I just check that? I think that's the point that my Lady Justice Thirlwall asked me just that question.
I think I was asking you about what they knew, wasn't it? What they'd been told. And I think you read out what the...
Yeah, maybe it's a different point. Kendall spoke to D1's call handler gave the facts of the accident. His back at a different point. His back and chest were hurting. I think he'd tried to flag down. Could you bear with me a minute? Yeah, I mean, I accept that there was no active direction or order. There was, funnily enough, I think, in relation to the fire service, and that we get that from Thomas's evidence that, well, the police said we weren't needed anymore, so we left. They left before the police, I think.
Is that in the pleading?
That's one of the unanswered questions, which I'm going to go to in a moment.
All right.
But what we do have, so what was the question?
Isn't it paragraphs 25 and 26?
I think it's paragraph 22 of the skeleton at core 36.
The skeleton.
22 of the skeleton.
Which might help here. The reference to GB 103, it's one of the officers, informing at 025 that the driver will be taken off to SMH, I think that's the hospital, for precautionary checks.
That's just.
I think this is
That's the police
this is
officer
the point.
telling the call handler, is it?
Yeah, this is the call. Well,
Yeah.
I think this is our answer to the factual part of ground one.
But that's
Where-
just an announcement of what's happening. It's not saying, it's not the police telling him what's
Well,
going.
hold on. I mean, this might be but certainly Mr. Warnock says that there was an error of fact, that the making matters worse conclusion is infected by a misunderstanding of the facts, because in fact he was never removed by the police. So it's the same point in that regard. And we at 22, we deal with that. Well, the overall macro answer is it doesn't actually matter. It's in fact a bit of a red herring, whether he was actively removed or not. If I'm right, yeah, I know, Your Lordship, certainly Lord Justice Stuart-Smith is not happy with this part of our case. I
Well,
accept
if I'm not happy,
that.
I want to make sure I've understood it properly.
Okay, all right, but what you're saying is there is no direction. And that's what
No,
was,
what I actually asked
or what you're
was,
asking.
what is your case? And I think the answer is to be found at paragraphs 25 and 26 of the particulars of claim.
Right.
And if there's anything else
We better tell you. Yeah.
which is admissible,
Yeah.
whether by amendment or not,
Okay.
I'd like.
Let me. Could I just? Yeah. Well, I'm grateful for you reminding me what my own pleading says. 25.
I didn't mean it like that.
Well, no. I'm sorry. I wasn't being cheeky. No. I mean, plainly, I should have said immediately. The answer is 25 and 26 of my pleading. As pleaded below. I mean, how I have summarised that during the course of my oral submissions is that the reality of what happened when you apply what we say as the test is that it was the inevitable consequence of them engaging that made matters worse, because it neutralised Kendall. I have to concede that we do not have the same sort of clear imperative direction that that you have, for instance, in Daly. We don't have that. But we have 25 and 26 of the pleading. We have the observations at 22A to deal with there was no removal point, to say, well, all right, that might be the case, but it's a red herring, but it's got to be read. Well, we say it's a red herring because it doesn't accord with our test. But first of all, they call the ambulance, that's 22B, and the police placed Mr. Kendall into the care of the ambulance service.
Do you maintain
And what
that?
he
Do you
would
maintain
say,
that?
what he would, hang on.
I'm really sorry, but do you maintain that? It's in your skeleton, it's not in your pleading, that the police placed Mr. Kendall in the care of the ambulance service, because that suggests a measure of direction which is entirely lacking from your pleaded case. I'm sorry to nibble at this, but I think it's right at the heart of the case, speaking entirely for myself.
It's also not entirely consistent with the statement, insofar as we have it, of Shelley Pearce at page 41A. Who is one of the ambulance personnel.
Yep. Sorry, could you say that again?
I said it's not wholly consistent with the statement of Shelley Pearce at 41A, one of the ambulance personnel.
Yeah.
She and her colleague exit the ambulance. They walk straight over to Mr. Kendall, take a board so that they could perform a rapid takedown on the patient, secured the patient on board and lifted him into the ambulance. I cannot recall speaking to any of the police officers present other than maybe just saying hello. My colleague Annette went straight over to deal with the patients who would most likely have spoken with those already present, and they took Mr. Kendall to Stoke Mandeville.
Well, I mean, this is an example of judging the legal argument against without evidence, because at 49 of the 49 of the supplementary bundle, paragraph 12 of Mr. Kendall's statement at tab 5, he says, by the time I finished my conversation with the emergency services controller, the emergency services had begun to arrive. I spoke to one of the police who arrived, and he walked with me to the car and examined it. He conducted a negative breath test, then placed me into the care of the ambulance service, which had also arrived. So placed me into the care of, along with the fire brigade. At this stage, I assumed that the police were clearly in control of the scene, so thought no more about it, and was treated at the scene and then transported by ambulance to the hospital. So that's what he says. But again, it's not at the heart of the case, insofar as we say that our approach, which I won't go over again, on ground one and making matters worse is right. And that you compare, sorry to repeat it, the hypothetical, what would have happened had they not turned up, with what really did happen. Now, there might be some difference between the witnesses about what really did happen. We certainly know that afterwards, Mr. Kendall was absolutely shocked about the fatal accident, because he thought, well, I did my best. The police were there. How on earth did this happen? So,
isn't that the consequences of what you say is the breach?
Well, possibly. Can I just go to these unanswered questions quickly, and then I'll got my concluding section.
And if you wouldn't mind, I would quite like to understand why that isn't simply a question of what's the consequence of the breach, rather than something to do with whether there's a duty.
Sorry, could you have to say that again?
Yes, the question I was asking was the hypotheticals of what would have happened if. Why are they not questions of the consequences of the breach rather than the existence of the duty?
Well, the existence of the duty is always, in every case, not to make matters worse. And are we talking about the fourth hypothetical?
Yes, I'm afraid I've lost track of your numbers, but that's probably it.
Yeah. Or the first hypothetical. Hang on, I'm getting confused. The first hypothetical was members of the public arrive and take over the warning from Kendall. Persons leave and there is an accident. Mr. Warnock says that person couldn't be liable.
No, I'm sorry, Mr. Bowen, we're at cross purposes. I mean, assuming Mr. Kendall had remained, the police had gone, or the police never attended, what would have happened next?
Yeah, well, that's precisely our point. That what would have happened next? Sorry, I have to take this off when I'm speaking because I get feedback.
I understand.
And when you speak,
And then you can't hear.
put it on
Yes,
again. Yeah.
I appreciate.
So the unanswered issues and questions for trial, which require a trial, are as we see it as follows. First of all, A, if the police had not attended at all, in order to make findings on the making matters worse point, there are two questions at least which need to be answered. When would the ambulance and fire service have attended? How long would they have stayed? I suppose you might add to that, would they have removed Mr. Kendall with or without his consent? We just don't know. Then B, second proposition. In the absence of the police, would the fire service have taken control of the scene? And that is definitely pleaded. One, and I put that in, I've got 9 separate scenarios about what would have happened if they hadn't come at all in relation to the fire service. One, would the fire service have cleared the debris from Mr. Kendall's accident? Fair guess is they probably would have done. 2, would they have carried out a detailed or any investigation as to the cause of Mr. Kendall's accident? Because let's not forget that one of the findings of the inquest jury, and it may or may not have been, it's all pleaded, so forgive me, the precise detail escapes me. But the gross misconduct charges as well were failures to carry out any form of risk assessment to actually see how dangerous the ice was. That's Tindall's evidence, Mr. Kendall's evidence about where they seemed to be pretty relaxed, they weren't in a hurry, and they didn't really check out the ice. And their answer to that is, on Mr. Warnock's pleading, I think, well, they thought that it was just cold and icy generally, and they didn't know that there was a specific localized problem in the area. 3, would they have been more observant than the 3 attending officers? And would they have noticed the ice hazard that was severe and localized? 4, would the fire service have appreciated an imminent danger to road users, including the danger of death? They had already, the car that came off went nose to tail, it went nose to boot. It was not just a little slip into the ditch. 5, would the fire service have attempted to slow the traffic by erecting 2 signs rather than the one that Officer Thames refers to at supplementary bundle, page 45? We know from that reference in the supplementary bundle that there was 1 sign. As far as I'm aware, there has been no, probably somewhere deep within the inquest bundle, exactly what the fire service could have done, what the policies and procedures of the fire service, standing instructions, that kind of stuff, suggests that the fire service should do in the absence of the police, who might be seen as...
Can I ask this, because it is this morning you've raised this point about Mr. Thames' statement.
Oh, hang on, sorry.
Mr. Thames' statement at page 45 of the supplementary bundle, which refers to the fire service bringing out its own sign and removing it. That is no part at all of your pleaded case. This morning you referred to 2 signs now being present, one by the police and one by the fire service. Given your pleaded case, what account are you saying this court should take of what is in Mr. Thames' statement?
Well, the way that this illustrates the fact that we have a pleaded case. The pleaded case does refer, I have to find the precise just bear with me a moment. There's 58B, that's 77. Further, but for the attendance of the police, the fire service would in all probability have taken control and remained at the scene and ensured the safety of road users until the ice hazard was cleared.
That's
I
not
appreciate there's nothing there
pleading.
about the sign.
No,
I take that point. But that might either be various possibilities there. Sloppy pleading by yours truly, one possibility. But that's not the case. Whether or not we simply spotted the point at 45A about the sign, it may well be that that point has just been missed. But it's a particular of a perfectly adequately pleaded case, which must surely satisfy the rules of pleading, which is to put a sufficient and succinct description of the facts that you rely on. And the facts that we rely on are at 58B, that but for the attendance of the police, the fire service would in all probability have taken control. The second part is that this is an example of the Vendanta Begum point, which is that at a trial, the full facts will be properly understood.
Well, that may be, but I'm still trying to understand what your case is, and certainly your pleaded case. For myself, I have difficulty with the notion, given the detail of this pleading, that if that point, namely the erection of the sign by the fire service, was something you were relying on, it wouldn't have been pleaded. The second point, and separate, is, in those circumstances, what would be the reliability of the responsibility of the fire service in removing it?
Well, that I accept, and we haven't sued the fire service.
No, you haven't.
But because we are not suing the fire service for that, doesn't remove the power of and the relevance of 58B, on which, of course, in the ordinary course of events, the defendant will simply seek further and better particulars, or rather a Part 18 request for further information in relation to what we meant when we said they would in all probability have taken control and remained, etc. And that's what I was going into in what we don't know.
Well, can I then come back to my question, Mr. Bowen, which is, given your pleaded case, what weight, if any, is this court to attach to the statement of Mr. Tone?
Well, I'm sorry to be a bit slow answering this, but you proceed on the basis of the pleading.
That's right.
I mean, that's fine. The Tome's second statement is only in because, of course, it's an application for summary judgment, and that's why that has some status. I stand by the pleading, subject to the submissions I've already made based upon Vendanta and Begum and Arundel. And what the fire service would or would not have done, how many signs they had, whether they had other methods of warning in their vehicle, how long they would have stayed, all of those questions, I'm almost finished going through them, are matters for trial. So whilst I entirely accept that you are perfectly legitimate in asking me that question, it is not a central question to the resolution of the issues in the case.
Well, that isn't the answer, is it? To
Well,
my question.
subject to Mr. Lima following, who will probably do a far better job answering the question than I have, that's my answer. Let me go back to the questions,
think you were on number 6,
Yeah.
getting to number 6.
I'm very grateful. Thank you.
But either you or Mr. Lima, I share my lady's concern.
Yeah.
If we're to have any regard to Mr. Thames' statement at all, what does it do? Don't feel you have to answer this
Yeah.
now. What does it do for your case on control?
I'm not sure I follow that.
Right,
Because the case on control relates to a case on control is based on the fact that it's an omission. It's a failure to confer a benefit case, and it comes within the exceptions. And one of the things I've got to do is to set out the precise scope of the duty. And I'll do that in a moment when I've just finished this section. I don't see immediately, and maybe I'm just being a little slow here, why what Mr. Thames says and what the fire service would or would have done in the absence of the police has anything at all to do with the fact that the police were there, were in control, and then relinquished control. And by the time they relinquished control, the fire service had left. So it seems to me that the question that your lordship poses is, with respect, I can't see how it does anything to weaken our case on control. Our case on control is entirely separate. And I'm delighted to say Mr. Lima agrees with me. But I mean, I don't know whether that's a satisfactory answer, but that's my immediate reaction to your lordship's question. I mean, if there is a link, then, and there's anything else your lordship needs to put to me on that to establish the link, then I'll happily answer it. But at the moment I can't see one, because the fire service have gone, the police were there, the police leave. But moving on to number 6, number 5 being the controversial one about the signs. 6, would they, the fire service, have closed the road? It's one of the issues in the inquest, and I dare say the misconduct proceedings, was whether the police should have closed the road. 7, would they have pressed for the council, or D2, or the highways agency? I'm a little confused about the relationship between the two. To urgently call out a gritting lorry. 8, would they have waited at the scene until the gritting lorry arrived, which is one of the criticisms of what the police did not do. 9, when they did leave, might they have left either their 1 or 2 or however many warning signs or bollards or whatever else they might give evidence to the judge that they would have done? So that's I've dealt with there. My 2 points on what would have happened if the police hadn't attended at all. My 9 points on what might have happened if the fire service had taken control. The third point, the third section, was, as the police claim, Mr. Kendall capable of staying to direct and warn the oncoming traffic? Supplemental bundle, page 10, paragraph 8 in particular, I got there. Paragraph 8. This is Mr. Knapp. So this is the witness statement on behalf of the first defendant, where he says, it sets up an argument that Kendall was in considerable pain, requested attendance in the ambulance, back-killing him, finding it hard to stand, etc. He basically says he didn't have the capacity physically, really, to be able to do what he is now being claimed in his second statement he would have done. I believe that the allegation that but for the attendance of the police, Mr. Kendall would have stayed to direct and warn the traffic is fanciful, nor do I believe that there is any factual basis for alleging that other identified drivers would have done so. Well, we've then got, although sadly I don't have reference to immediate hand, what he would have done. Yes, paragraph 18, supplementary bundle, page 49. Paragraph 17, the first thing I say is that it was obvious to me and should have been obvious to anyone attending and seeing the sheet ice that another accident was very likely to occur. 18, to be clear, and if I had realised that no help was going to be forthcoming from the police, I would have done my very best to warn other motorists on the sheet ice, and in fact, I tried to do so precisely. And when attending to flag the van described at paragraph 9 above, and before diving at 101, there's another section somewhere about how he was up to it. And Mr. Lima will give me that reference. It doesn't immediately...
I think paragraph 20 may be what you're looking for.
Yeah.
5 lines from the end.
Oh yeah, I'm
optimistic
yes,
that
that's
the police
following on.
not right.
I've explained at 8 and 11 that I was suffering from pain. I think I think Mr. Warnock took you to this. You can see there it's saying 5 to 10. In fact, it wasn't. I was in some pain, but I wasn't in such pain that I couldn't have continued my attempt to rescue. How long would he have continued waving? Would Mr. Kendall have succeeded in getting his red warning triangle from the boot of his car? It's another theme. Would other motorists have stopped? If they had stopped, might they have put hazard lights on and put out their own warning triangle? And then my fourth theme, would on a burden of on a balance of probabilities, would no. Yeah, well, I'm not sure this next one may... Give me a minute. My next two sections, those on burden of proof and causation, which I needn't go to. So there is a whole series of questions that have got to be answered when carrying out the process that we see Lord Justice Stuart-Smith said when you compare the hypothetical with the reality of what happened. That deals, I think, with everything, save 2 points. Just forgive me a minute. Right, this is the scope of the duty of care. We say in relation to control, the defendant owed a duty of care to Mr. Tindall as a member of a restricted and delineated class, that having taken control of a known and serious hazard on the highway, the defendant would not relinquish that control without taking reasonable steps to address the danger. That's what we say, and if you want, we can print, type that out and hand it up to you, so there's no doubt about the words we use. That leaves just some short conclusions to sum it all up.
Rather than you have to type it out. Have I got this right? Defendant owed a duty of care. Sorry. The defendant owed a duty of care to Mr. Tindall as a member of a restricted and delimited class.
Delineated class.
Delineated?
Yeah.
That having taken control of a danger on the highway, they would not
a known and serious hazard.
Of a
having
known
taken
and serious hazard, danger on the highway, they would not relinquish control without taking reasonable steps to obviate the danger.
Yeah, or we said address, but obviate. Yeah.
Okay.
Yeah.
Thank you.
Oh, we can use different language, but so that's the scope of the duty. And then in terms of sweeping it all up and trying to bring the various themes together, we say as follows. And I'm addressing here the similar exercise that Mr. Warnock did at the end of his address. He says the road was exactly the same as before they attended. We say no. Disagree with that. This is a case where the police increased the hazard and left the road or left the whole scenario in a worse state than they had found it. On arrival, Mr. Kendall was in situ. He would have proceeded to warn other motorists, and for the purpose of this strikeout application, would have succeeded and the accident would have been prevented. When the police left, Mr. Kendall was not there and nothing was in place to warn of the black ice. So they had the signs are effectively doing what Kendall would have done, but they've lost the signs, they've lost Kendall. The road was the scenario, stroke the road, was thus plainly in a worse state than when they found it. Secondly, it's true that one, the police did not instruct Kendall to desist from a rescue, and that he was not in the process of rescuing Mr. Tindall at the time. This is the discussion that you had with Mr. Warnock, the court had with Mr. Warnock relating to OLL and the narrowness. I think Mr. Warnock himself referred to it as being a slightly nuanced differential about precisely whether the example he gave as well, about whether the person was actually in the process of being winched out of the sea. So it's true that that is the case. There was no instruction to desist. And also, number two, the mere arrival of the police and the removal of Kendall from the scene were not, as isolated incidents, negligent. But those are not prerequisites, we say, for a duty to be found. As regards control, it's right that the police were not in control of the road or black ice at the time of the accident. We accept that. But one, this is not a requirement. Two, it's the fact that they negligently relinquished control and that they had the power and ability to influence the outcome, couch, etc. Where they had the ability to exercise control. That is what the issue is. Three, it's precisely the same as Dorset Yacht. The Borstal officers did not have actual control over the buoys at the time the damage was caused. They had relinquished control in circumstances in which they could have exercised it. A.J. Allen is the right approach. The two justices that I referred to, Lady Dorian and Lord Drummond Young. Next point, further, the relationship between the police and Mr. Tindall is established by the fact that only a limited class of individuals could be potential victims, owing to the location and time-specific nature of the hazard. Next point, we don't seek to argue that a highway authority would be liable to any member of the public who come across any hazard on the road. That is plainly a different scenario, since, firstly, the police had taken express control of the specific location where the ice was situated before relinquishing it, whereupon an accident took place shortly thereafter. And secondly, that's very different from a contention that as the agency with general responsibility for the roads, the highway authority can be construed as having control over all hazards on the road at all times. And just a few words, if I could just go back for a minute to the point, I think your lordship was searching for a passage which in fact I think I had taken you to, paragraph 73 in Gorringe, and we had a interchange about, well, what's the difference in terms of control, and just a little more detail on that. The difference between the Gorringe scenario and ours, first of all, it's entirely different, apples and pears again. The police put the sign up etc. It's a wholly different scenario to taking control of the scene. So when they take control of a previous existing accident where there is ongoing danger, that is completely different to Gorringe. 4 short points. There was an emergency. Compare that to a long-standing failure to do something, because Gorringe is a doing nothing case. Secondly, the police were specifically called and aware of the danger. That's a differentiating factor from the Gorringe scenario. 3, they took over the scene and took control in a short temporal sense. 4, they relinquished control not having dealt with the underlying danger, which was again a completely different set of facts to the type of case that Gorringe is. Finally, we say this case is absolutely not about using the control exception as an attempt to go behind what was said in Robinson. It's a case firmly premised on the law as set out from Michael onwards in the 3 Supreme Court cases. And our case fits firmly either within causing harm, making matters worse, or one of the exceptions, to Forest 2 or to Forest 3. If the impact of the application of the control exception is that a particular public authority is found to be liable on a particular set of facts, then that's simply the effect of a working, fairly balanced system of justice. And I've already addressed you on the tension that exists in this area of the law between protecting the public authorities and allowing the right type of case to get through the system. We recognise and accept that there is scant recent analysis on the way in which the exceptions have been satisfied. That's the point that Lord Justice Coulson makes in a slightly different context, but very analogous, at paragraph 71 of Begum. Fast developing area in the law of negligence. A strong reason for not striking out, or no reason to strike out. The case, in our respectful submission, really must go to trial. And I think, unless there is anything else, and subject to Mr. Lima wanting to add anything, those are my submissions. Oh, yes. Professor Fairgrieve, Dr. Fairgrieve would rather be known as Duncan Fairgrieve.
My compliments to the professor.
So, but you can call him what you like. No, I think just plain Duncan, if that's okay.
But if we refer to you as Mr. Bowen,
certainly not.
If we refer to you as Mr. Bowen, just on the front sheet, we refer to you as Mr. Bowen and Mr. Limar. Mr. Fairgrieve?
Yeah.
Okay, fine.
Yeah.
I've got.
You can promote me if you want. You can call me something on grander.
Maybe.
Title of your choosing.
Can I just? I got a bit lost, and I'm sure it's my fault.
No, probably isn't.
But you asked if the police had not attended, what would have happened, and you gave 9. You asked 9 questions, starting with would the fabricator clear the debris and so on and so forth.
Yeah, I did.
What is the point of that submission? Is it meant to go to the existence of duty, or is it what? Because at the moment I don't see how it fits into the argument.
The point of that submission is that I think there are 2 points. It fits potentially into 2 different areas. One is it's us supporting the Vedanta and Begum point about how important it is to actually know, not only applying the making matters worse test as we construe it, but not only what did happen, but what would have happened. So it goes to the hypothetical question. And I think it also goes, and therefore it goes to our argument about ground 1, and the wider or macro approach that you take for the reasons set out in paragraph 23 of the skeleton. I have concurrence from behind.
Thank you.
So unless there's anything else, that's certainly me done. My submissions.
Thank you very much indeed, Mr. Byrne.
There's no following.
Thank you. Mr. Ward.
I should be finished by about 3:15 at the latest.
Thank you.
First point, my learned friend took the court to Capitals and Counties, page 1034. It's at page 222 of the bundle, tab 6.
I'm sorry, Mr. Warnock, the fault is mine. Which page?
Page 1034, internally, page 222 of the bundle. The important point to note about this passage is it was addressing a submission on causation that counsel for the defendant was relying on in the appeal. Counsel for the defendant was arguing that the case should have failed on causation grounds because in assessing causation about the effect of turning off the sprinklers, the judge should have assumed that the fire brigade hadn't turned up. So it wasn't looking at the duty stage, it was looking at the next stage of the analysis, or a stage beyond that, duty then breach, then causation. And it's important that that submission is read in that light, and we see that at between C and D. We do not accept Mr. Mumby's submission. Well, I should start with Mr. Mumby's submission. Mr. Mumby relied upon the judge's finding at letter B, a rather lack of finding as to what would have happened if the fire brigade had not turned up at all. The judge said he was unable to say whether or not, on the balance of probabilities, that the fire brigade had done nothing and the sprinklers had been left on, the building would have been burned down completely. Mr. Mumby submitted that in the absence of a positive finding, the plaintiff's case must fail, since the burden of proof rests on the plaintiff to show all necessary elements for recovery. We do not accept Mr. Mumby's submission. The danger with fire is that unless it can be controlled and prevented from spreading at a relatively early stage, it will quickly become out of control and consume all in its path. That danger was particularly acute having regard to the construction of the roof at the Crescent, having negligently turned off the sprinklers which were at that stage containing the fire. The defendants, by their positive act, exacerbated the fire so that it rapidly spread. The question is thus one of causation and has to be tested with the benefit of hindsight by comparing what would have happened if the sprinklers had been left on with what in fact happened. And that is what the judge did. So that's the context in which that passage has to be read. Turning to my second topic in reply, control. It is important to bear in mind that Robinson and Poole, the Supreme Court in both of those cases, were not unleashing some form of legal revolution, and quite the opposite. What Lord Reid emphasised in both of those cases was that the law was having a return to orthodoxy, that is, established common law principles. And established common law principles exist concerning the class of persons affected by a danger on the highway. And they've been considered by courts at the highest level, this court and the Supreme Court. In Ansell, Stoven, Gorringe, and Sandahar. Ansell, the relevant passage, we looked at it yesterday, it was at page 244 of the bundle. It's tab 8. No, it's not tab 8, sorry. Tab 7. sorry, it's tab 4, and it's not page 244, it's at page 153 of the bundle, page 243 of the report. Look, this was a case, of course, about the police coming upon a danger on a specific road, as it happens near Luton Airport. But at the bottom of page 243, His Lordship, Lord Justice Beldam, said, I approached the question of the existence of a duty of care in the present case with these considerations in mind. Firstly, as Lord Keith pointed out in Wan Kan Yu, an Attorney General of Hong Kong, there was clearly a special relationship between the prison officers and the owners of the yachts, so close and direct that the duty to take reasonable care to prevent damage to the yachts arose. But as his citation from the judgment of Dixon in Smith and Lurs shows, it is exceptional to find in the law a duty to control another's actions to prevent harm to strangers, and where they are found, they arise from special relationships. When it is contended that such special relationships arises out of duties carried out in the performance of a public office, the court must have regard to the purpose and scope of the public duties, whether they are intended to benefit a particular section of the public, e.g. investors or depositors, or whether such persons could reasonably place reliance on the fulfilment of the duties. And secondly, such a duty of care would impose upon a police force potential liability of almost unlimited scope. Not only would the class of persons to whom the duty was owed be extensive, but the activities of police officers which might give rise to the existence of such a duty would be widespread. The constable on the beat who failed to notice a danger on the pavement, or noticed it but dismissed it as insufficiently serious to warrant his attention, the officer who searched for but failed to find property when he might have done, or the officer who misinterpreted a breathalyzer reading, might all be said to come under liability to anyone who could show that they suffered injury or loss as a result. So what His Lordship is saying there is there needs to be something which takes the claimant into a special relationship outside the existence of the general public who may be foreseeably affected by the danger, the same point that was made in Gorringe. The danger on the road in Gorringe was a danger to any member of the public who drove down there. There was nothing special about the relationship that the claimant had with the highway authority. That's paragraph 73 of Gorringe. It is worth looking at again, page 292 of the bundle. Tab 9. As the speech of Lord Scott, paragraph 73, internal page 1078, page 292 of the bundle. There are, of course, many situations in which a public authority with public duties has a relationship with a member of the public that justifies imposing on the public authority a private law duty of care towards that person. And the steps required to be taken to the discharge of that private law duty of care may be steps comprehended within the public duties. See Barrett and Phelps. But the council in the present case had no relationship with Mrs. Gorringe that it did not have with every other motorist driving on the stretch of road in question. And with respect to my learned friend, a temporal distinction in relation to Gorringe will not do. He says, well, Gorringe involved a danger which had been there for a few years because the sign had disappeared for a few years. But could it seriously be suggested that the result in Gorringe would have been any different? And Mrs. Gorringe's case would have succeeded if she had been the first person to drive over the stretch of road after the slow sign was obliterated by the repair works.
But it's more than a temporal point that was taken, wasn't it? It was really the second point that the police had been specifically called and were aware of that specific danger.
Yes, but it's a danger as in the Ansell case, which anyone who comes down the road in question, from whencever they may come, faces. There's nothing peculiar about Mr. Tindall and his relationship with the local authority, which puts him in some different relationship with the local authority. And in fact, or with the police, sorry. And in fact, one has Sandhar, which is specifically a case about ice. And nobody disputed that the highway authority in Sandhar had a duty under public law terms to have salted the road. In fact, it generally did salt the road. But on the particular night of this accident, it hadn't salted this particular road. But the Court of Appeal held the fact that that gave rise to the obvious danger that people going down that road may lose control of their vehicles and have an accident, as indeed happened to the plaintiff, Sandar, did not give rise to a duty because he was in no different a position than anyone else who was driving down the road. There was no special relationship between him and the highway authority. And my lady, I do say this, it does seem, my learned friend says, well, the police are different. It does seem rather extraordinary that it's the highway authority which has control of highways. It's the highway authority which owns them. It's the highway authority which has statutory responsibility for maintaining their safety. It would seem rather extraordinary if the highway authority is not liable where it allows ice to actually form on the highway, which it could have prevented. But the police who attend the highway for a short period of time are held to sufficient control.
You're not comparing like with like, with respect. You're not comparing like with like. The highway authority's responsibility is to maintain the road, including with the adjustment to section 41.
Yes.
And that's a general duty.
Yes.
Of which it can be said it's owed to every road user. The point I think my lady makes, and the point that Mr. Byrne makes, is that that's different from the present case where the police are called on a specific problem. Now clearly, if the highway authority had been called out with the same degree of urgency, one can see an equality between them. But that's not really what we're talking about, I don't think.
Well, I'm tempted to refer back to what I think it was Sir John McGauls who said in Ansel McDermott about actually the primary responsibility in relation to dangers on the highway is the highway authority. He said that was another reason why the police shouldn't be liable in that case. But I'm not sure it is a difference, actually, because in both cases, if one's analysing it from a legal perspective, one's analysing it from the point of view that there is a danger which foreseeably poses a danger to people coming down the road. And whether that danger arises because the highway authority, on a very cold night, a winter night, where it is accepted it should have salted the road, doesn't do so, so it's going to know the road is icy and doesn't do anything about that. I'm not so sure it is anything other than a difference of degree. To say it's a difference if they're called out to a specific icy patch. It's difficult to see that the result in Sandhar would have been different had the highway authority received a call telling them the road was icy that night or that cars were skidding on it. We're very far removed from the facts of cases like Dorset Yacht, where you have a public authority which has got people in its charge, and then you have an extremely, the class of people affected by their escape are the ones who could only be affected by their escape because the only way off the island was to take the yacht. So you've created a danger, you've brought them onto the island in circumstances where if they do escape and you breach your duty, there's a very limited class going to be affected. But it is important to bear in mind that in Dorset Yacht itself,
would it be wrong in principle to regard the Borstal boys as akin to a CS gas canister?
No.
That's what I thought.
They clearly were, because they were brought onto the island in circumstances where it created a danger. But it is important to bear in mind in Dorset Yacht that Lord Diplock also drew a distinction between the yacht owners who were likely to be directly affected by the creation of that danger and members of the public generally, because once the Borstal boys got onto the mainland, there could have been no question of the Home Office being liable for any harm they did to people on the mainland. It was very strictly limited to the fact that they only had the means of escape using the yachts. What my learned friend seeks to argue is that there's a duty to anyone who uses the highway, but it really flies in the face of what the House of Lords said in Gorringe and Stoven about people having to take the highway as they find it, about there being no special relationship unless you come within a category which distinguishes you from anybody else who might use the road in question. The Scottish cases really don't assist. Gibson and Orr, as my learned friend pointed out, predates Gorringe. It involved quite a lengthy policy analysis of the law by Lord Drummond, or Lord Hamilton, which we know from recent authority is the wrong approach. And it's in the Allen case, my learned friend didn't take you to the speech of Lady Patten. It's tab 19 of the bundle. And at paragraph 25 on page 621, or page 313 internally, Her Ladyship said the third matter arising from the authorities cited in paragraph 14 is the marked divergence between Scottish and English lines of authority in the context of the potential liability of a fire brigade. The Outer House decisions of Duff and the Highlands Board, Gibson and Orr, and Burnett and Grampian Fire and Rescue Service criticised and departed from important aspects of the English authorities and concluded that certain averments of alleged negligence were in those cases relevant for proof in circumstances where an English court faced with the same averments would be likely to have struck the cases out as irrelevant. And she went on to say at paragraph 33 on her analysis of the law following of Michael, it follows that this court must disapprove of the Scottish authorities of Duff and Highlands and the Highland and Islands Fire Board, Gibson and Orr, and Burnett and Grampian Fire and Rescue Service. It is notable that the courts in these cases did not have the benefit of the guidance given by the House of Lords and the UK Supreme Court in Mitchell and Michael. And it is right to say that she cryptically said at paragraph 36, I agree with the defendant senior counsel, it's possible that the result achieved was correct. but the reasoning does not accord with the line of authority from East Suffolk Rivers Catchment Board, Kent to Michael. It is also important to bear in mind in relation to the Allen and Strathclyde Fire Board case, where it fits in the chronology of the Supreme Court decisions, because it was decided after Michael, but before the clear exposition of the law which Lord Reid was to give in Robinson. And my ladies and my lord will recall that when I made my submissions yesterday, I pointed out that Lord Reid specifically said that following Michael, there continued to be a misunderstanding. People hadn't fully grasped the fact that we had left behind these issues of policy, and one sees references to policy actually in the Allen and Strathclyde case. And he spelled out in terms which are clear the fact that the duties owed by public authorities are no different from those owed by private individuals. And in fact, one sees, if one goes to the decision about my learned friend took you to the speech of Lord Drummond at paragraph 95 of the judgment, paragraph 96. At paragraph 96, he said, I hope that in an appropriate case the law might develop in such a way, and that's, sorry, one needs to read 95 to get the flavour of it. He said, in my opinion, the distinction might be drawn between injury to the person and damage to property. In part, this reflects the fact that the latter is usually covered by insurance, while the former is not. More important, however, is the fact that the life, health and safety of the individual possess a greater moral significance than the security and integrity of any property. A normal person will attach greater importance to his safety than to his property. The parable of the Good Samaritan would lose nearly all of its force if the man who went down from Jerusalem to Jericho had merely dropped his purse, which the Samaritan saw and returned to him. Consequently, I hope that in an appropriate case the law might develop in such a way that at least in clear cases where action can be taken without danger to the rescuer, the officers of a public service, such as the fire service or police, are obliged to take action to rescue persons in danger. I realise this must require further exception to the general rule. But in fact, that hope which his lordship expressed is not one that has found favour in the Supreme Court subsequent decisions in Robinson and Poole, because the Supreme Court in Robinson and Poole have, in fact, as we looked at yesterday, said there is no distinction to be drawn between public services and other legal persons in terms of whether they owe a duty to act. And the final point to be made about this case is at page 632 of the bundle, paragraph 62 of the report. My learned friend did take you to this, but I want to emphasise at the end of paragraph 62, subparagraph 2, his lordship also pointed out that the notion of control also underlies the liability of road authorities in Scots law to take reasonable care to remove hazards. And you may recall there was also a reference made to this distinction between the Scots common law and English common law in Gorringe by Lord Rogers, because Lord Rogers said in Gorringe at paragraph 84, it's tab 9, paragraph 84. That the common law of Scotland is somewhat more generous to those injured due to the failure to maintain the roads than was English common law. And of course, if it's more generous to claimants against the highway authority in relation to such dangers, it's not such a big leap to make it more generous in relation to the police. But whether or not it remains the law of Scotland, Gibson and Orr is certainly not the law of England. It is simply with respect to the Scottish court, if they did intend it to be the same as the law of England, and Lady's patent judgment suggests not. But it is simply irreconcilable with Gorringe, where the placing and removing of a sign was expressly held not to be sufficient to justify or generate a duty of care. Because the key fact in the Gibson and Orr case seems to be that the fact that the police are said to have assumed control by putting a sign out on one side of the road, although not the relevant side that the driver was coming from. But it's impossible to reconcile that with Gorringe, where the Supreme Court, and as I said yesterday, every judge in the Supreme Court agreed with every other judge's judgment, and where Lord Rogers pointed out in the passages we looked at yesterday that if you put down a sign and then you remove it later, you've returned the position to the status quo ante. It cannot sensibly be said to have created any danger.
So on that view, there has to be something in relation to the removal of Mr. Kendall which creates a duty.
Yes. But what we're left with Mr. Kendall is somebody who voluntarily goes off with an ambulance. As I submitted yesterday, it's not suggested in any way that anybody said, you must go now from the point of view of the police. He wasn't even waving traffic down when the police arrived, so nobody said, you must stop doing that. Mr. Kendall is a free agent individual who decided to go off in the ambulance. And as I looked at yesterday through Capital and Counties and OLL and indeed Daly and indeed Sandhar, the law is that the fact that the emergency service attend is not by itself enough to create a duty of care. The fact that members of the public may assume under some sort of general reliance principle that if the emergency services attend, they will do something is not enough to generate the duty of care. And our facts in this case do not go beyond that. Just on the point again, going back to the point about whether about the hazard and whether you're called out to it, knowing it's dangerous, can I just remind the court the facts of Stoven were that there had been, I think, at least 3 serious accidents at the dangerous junction. That's why the Highway Authority had decided they were going to do something about it. That's why they sent the surveyor out to talk to the British Rail who owned the land on which the dangerous, or the bank that blocked the view was sited. Coming back to my Lord Stuart-Smith's point about is this really different because the police are called out to an accident which, where they can see there's a danger on the highway, I really submit it isn't, because in a sense that is the fact of Stoven. You have previous accidents at a known dangerous site. The Highway Authority is aware of them. But even though they're the Highway Authority, which actually own the road and have the statutory powers to do something about it, no liability.
And it would have been the same if it had been a tendency to go icy.
Yes, as Sandhar
That's your
Sandhar
submission,
establishes. Yes. Can I make two separate points have arisen, I think, in relation to striking out? Excuse me. The first is the relationship between striking out and summary judgment, where one looks at the pleadings. There's a very helpful note on this, which I'm grateful to my learned junior, Miss Davies, for drawing to my attention at paragraph 3.4.21 of the White Book. And at the very end of that, the entire note's worth reading at 3.4.21, but I'll read out just the very last paragraph of it because it may be thought to be rather on point. And it's in a case called Independence Advantage Insurance Company Limited and Cook, the decision of this court in 2003. The defendant applied to strike out the claim under 3.42a, i.e. that even assuming the claimant could prove the facts alleged in his particulars of claim, he had no reasonable grounds for bringing a claim. The defendant did not allege any additional facts so as to justify a strikeout on any other ground, but did make a second application for summary judgment under Rule 24.2. The Court of Appeal considered the application under 24.2 to be superfluous if the particulars of claim had disclosed reasonable grounds for bringing a claim. Both applications would fail. If the particulars of claim disclose no reasonable grounds for bringing the claim, the court would have ample power to strike it out and enter judgment for the defendant, therefore making any recourse to Rule 24.2 quite unnecessary. And my learned friend's reference to the witness statement of Mr. Knapp in his submissions reminded me of a distinction where the Rule 24 application may have made a difference, because as you may recall, Mr. Knapp took a point that actually it's really quite fanciful to imagine that Mr. Kendall, who in truth went off on a spinal board, would have been standing waving down traffic forever. That's a classic summary judgment point. I have accepted for the purposes of this application what's pleaded, which is that Mr. Kendall, had the police not attended, would have stayed to flag down traffic. So my submission is this application is supposed to be determined on its pleadings. It is a proper strikeout case on the basis that even if the facts alleged are pleaded, the case is bound to fail because it doesn't disclose a cause of action in accordance with the established law. The second point on striking out is the vendetta and Begum point which my learned friend makes. The vendetta and Begum cases were dealing with what are described in terms in both cases as novel claims. That's not the case here. My learned friend expressly submitted this morning, and I agree with him, that he's not seeking to argue this case as novel. Both of us are arguing about the application of the established principles. And in particular, whether the mere attendance of an emergency service is enough to generate a duty because of the general expectation that they'll do their job properly by people like Mr. Campbell. This is, we're in an area of law where the Supreme Court have looked at the principles comprehensively in 3 recent cases. Older cases containing the established principles, such as Capital and Counties and OLL, Gorringe and Stoven, have all been have all received the judicial blessing in their analysis. We are really in an area where the law is established concerning the duties of public authority services and rescuers. And it is a simple question of whether on the facts alleged within that established case law, a legally recognisable claim is made out. If the particulars of claim do not allege facts, as we submit they do not, which even assuming they are true, disclose an established, disclose a basis for liability, then it should be struck out. Otherwise, we may as well not have a strikeout provision in the CPR of this nature. And there are obvious benefits to all concerned in having it struck out if it's bound to fail. As Lord Hoffman and indeed other members of the court said in Gorringe, they found it a matter of deep regret that Gorringe had resulted in a lengthy trial process and trial in circumstances where actually at heart the principles at issue were really involved straightforward principles of law, and it was always going to fail. And it is difficult to see, I submit, how the arguments my learned friend makes are going to be any more coherent or in any way different after a full trial in this case. As I've said in my opening, many of these cases, including Michael and Poole themselves, but also OLL, several of the capital counties cases, Van Col, they've all been dealt with by way of strikeout. And the courts shouldn't shirk from doing so here. I'm sorry, I was 10 minutes longer than I promised.
Only 7 minutes. Thank you very much, Mr. Warnock. We'll reserve judgment, will rise. Draft judgment will be promulgated in the usual way, on the usual basis. And you'll be informed when that's about to happen. Thank you all. All rise.